I want to tell you what it feels like to sit in a courtroom and listen to the two people you love most in the world describe you as someone you do not recognize. It is not anger exactly. It is not grief exactly. It is the specific disorientation of a man looking at his own reflection in a mirror that has been deliberately distorted, watching it move when he moves, speak when he speaks, and not resembling him at all. My wife Sandra cried. Genuine tears, or what looked like genuine tears. I no longer trusted my ability to distinguish between the two. She told the judge I had been controlling, distant, financially abusive, a man who kept her dependent and isolated and afraid. She said these things in a clear and composed voice with occasional breaks that the attorney beside her managed with the practiced timing of someone who had coached that performance. My son Elliot, who was 31 years old and who I had coached through Little League and driven to college and helped move into his first apartment and called every Sunday morning for 12 years, sat in the witness box and told the court that I had intimidated his mother for decades, that I had used money as a weapon, that he had watched his mother live in fear and had not known how to help her. He cried too. He was not coached as well as Sandra. His crying had the quality of a man who is doing something that costs him something, which I noted without being able to fully interpret. I sat at my table and I listened to all of it. I did not react visibly. 34 years as a forensic accountant had trained me to receive information without broadcasting my response to it, because the response is your own property, and you do not give it away in a room where other people are watching for it. And I thought about the file on the table in front of my attorney. My name is James Alderson. I am 65 years old, and by the time I finish telling you this story, you are going to understand why a single file and a single question from a judge changed everything in that courtroom. Welcome to Dad's True Emotions. Get settled and stay with me because tonight I am going to take you somewhere real. Drop a comment and let me know where you're watching from. Hit that like button and make sure you're subscribed. You are exactly where you need to be. Let me tell you about Sandra before I tell you about the courtroom. Because the Sandra in that witness box and the Sandra I married 31 years ago require distinguishing. We met at a conference in Atlanta in 1991. She was a hotel events coordinator, and I was a forensic accountant attending a financial crime seminar, and we ended up at the same table at a dinner function. And she told me a story about a catering disaster that she had resolved through sheer organizational force that made me understand immediately that this was someone who could handle anything. She was warm and funny and decisive, and I was, by comparison, someone who was more comfortable with spreadsheets than people. And we fit together the way things fit when the absence in one person is the presence in another. 31 years, a son, Elliot, a house in Raleigh that we built carefully over 20 years of deliberate choices, a marriage that I believed, without reservation, was solid in the way of things built on honest foundation. I was wrong about the foundation, not about the marriage being solid. The marriage had been solid. I was wrong about what was underneath it. The first thing I noticed was the attorney, not Sandra having an attorney, which was her right in a divorce proceeding and which I had engaged my own counsel to address. The attorney she had retained was a man named Gerald Prout who specialized, according to his firm's website, in high-conflict divorce and asset protection litigation. Sandra had told me 2 weeks earlier that she wanted a simple, uncontested separation. The attorney she had hired was not a simple, uncontested separation attorney. I told my attorney, a methodical woman named Frances Holt, who had practiced family law for 22 years, that I believed the proceeding was going to be more adversarial than Sandra had represented. Frances said, I assumed as much from the filing. Start pulling your financial records going back 7 years. I pulled 7 years of records. I am a forensic accountant. Pulling records is what I do. I pulled everything. Personal accounts, joint accounts, business accounts, investment statements, tax returns, property records. I built the kind of complete financial picture that I would have built for a client, which is to say the most complete possible picture, because in forensic accounting, you never know which detail is going to matter until you find the one that matters. I found the one that mattered on a Thursday evening in October, 11 days before the court date. It was a wire transfer, a single transaction from our joint savings account to an account I did not recognize, dated 14 months earlier, $42,000. The receiving account was registered to a limited liability company in Delaware called Meridian Family Consulting, which is the kind of name designed to be unmemorable. I looked at that transfer for a long time. Then I called Frances. She was quiet on the line for a moment after I read her the details. Then she said, "James, pull everything on that LLC." I pulled everything. Meridian Family Consulting had been registered 18 months prior. Its registered agent was a law firm in Wilmington. Its listed manager was a woman whose name I did not recognize. Its stated purpose was Family Financial Advisory Services. I ran the manager's name through the professional databases I had access to through my firm. She had no professional certifications in financial advisory. She had no public professional history at all. She was, by every available record, a private individual with no apparent connection to financial services. Then I ran the LLC's EIN through the tax filing databases. The LLC had filed a return showing consulting income of $42,000 received from a single client. The client was identified by a taxpayer identification number that, when I traced it, resolved to Sandra's personal account, not our joint account, her personal account, which I had not known existed. Sandra had a private bank account in her own name that I had not known about for at least 18 months. I called Frances back and told her what I had found. There was a longer silence this time. "James," she said, "how deep does this go?" I spent the next 4 days finding out. It went deep enough. The personal account had been opened 22 months before the divorce filing. It had received a total of $98,000 in transfers over that period, originating from sources including our joint accounts. A home equity line of credit drawn against the Raleigh house that Sandra had opened in both our names without my knowledge, and 3 transfers from an account registered to Elliot that I had not expected to find in the picture at all. Elliot's involvement was the hardest part to process. I sat with it for 2 full days before I could look at it clearly, not because I was surprised by the financial mechanics of it, because he was my son, because I had called him every Sunday for 12 years, because whatever was happening, he had been part of it long enough to make 3 transfers from his personal account to the structure Sandra had built. The home equity line was the most legally significant element. It had been executed with my forged signature, a notarized document that bore something close to my handwriting, but not my handwriting, that Frances sent to a questioned documents examiner the same week. The examiner's report came back 4 days before the court date. The signature was not mine. The conclusion was stated in the plain and certain language of someone who had examined documents professionally for 23 years. Frances built the file. I want to tell you what that file contained because every piece of it was placed there deliberately. The complete transfer history from joint and personal accounts, color-coded by origin and destination. The Meridian Family Consulting registration documents and the tax filing. The personal account statements going back 22 months. Elliot's account transfers, 3 entries, dated, amounts, receiving account confirmed. The HELOC documentation with my forged signature. The questioned documents examiner's report. And a timeline, prepared by Frances and reviewed by me for accuracy, that laid every event in sequence on 11 pages of clear, organized narrative. Frances had it bound with a blue cover. She placed 3 copies in front of her at the counsel table on the morning of the hearing. She placed a 4th in front of me. I want to tell you about the quality of Sandra's performance before I tell you about the judge, because it matters to the story. She was good. She had clearly prepared carefully and at length. The narrative she delivered about financial control, about isolation, about a man who had managed every dollar of their marriage and left her dependent and afraid, was coherent and specific, and delivered with the emotional authenticity of someone who had rehearsed it until it felt real. Her attorney guided her through it with the practiced ease of someone doing exactly what he was paid to do. Elliot was less polished but more affecting. He had inherited in some form my quality of not showing more than he intended to show, and what he showed in that witness box was the genuine conflict of a man doing something that cost him something. He described specific incidents, evenings when he had seen his mother upset, conversations in which she had told him she felt controlled. He cried. The jury, had there been one, would have believed him. I sat at my table with the blue-covered file in front of me, and I kept my face where I had put it. Then Frances stood up. She said, "Your Honor, before the petitioner's counsel proceeds to closing remarks, I would like to request that the court review a document file we have prepared relating to the financial history of this marriage." Gerald Prout objected on grounds of timing. Frances noted that the materials had been disclosed to opposing counsel 48 hours prior, which was accurate. The judge, a woman named the Honorable Patricia Wells, who had been on the family court bench for 14 years, and who had the specific quality of someone who has seen every variety of human behavior and retains the capacity to be interested anyway, looked at Gerald Prout and then at Frances and then said, "I will review the file." Frances walked the file to the bench. Judge Wells opened it. The courtroom went quiet in the particular way courtrooms go quiet when something is shifting. I watched the judge read. I had learned in 34 years of presenting financial evidence to various authorities to read the reader. Judge Wells read the way experienced people read when they have encountered something they were not expecting, slowly and then more slowly, going back to check a detail, moving forward, going back again. She read for 11 minutes, I counted. Then she looked up from the file. She did not look at Frances. She did not look at Gerald Prout. She looked at Sandra. And she asked her one question. "Mrs. Alderson," she said, "can you explain the purpose of the Meridian Family Consulting transfer in the amount of $42,000 dated 14 months ago?" The courtroom held very still. Sandra's attorney started to say something. Judge Wells held up one hand without looking at him. The hand of a woman who is asking a question of a specific person and is not interested in intermediaries. Sandra looked at the file, then at the judge, then at the table in front of her. She said nothing for a long moment. The moment stretched past the point where silence is neutral and became the kind of silence that is itself information. Gerald Prout leaned toward Sandra and whispered something. She shook her head slightly. "Your Honor," she said finally, "I would like to speak with my attorney before responding to that question." Judge Wells looked at her for a moment. Then she said, "We will recess for 30 minutes. We stood, she left. In the hallway during the recess, I stood with Frances near the window and she said, very quietly, that went exactly where it needed to go. I said the question was the right one. She said she knew exactly what was in that file. She asked the one question Sandra cannot answer in front of me. I looked out the window at the street below. Normal Tuesday morning traffic. People with ordinary Tuesdays walking past a building where something significant had just happened. When we went back in, Gerald Prout asked for a continuance to allow his client time to prepare additional documentation. Judge Wells denied the continuance. She said the matter had been scheduled for hearing and would proceed. She said she had reviewed the financial documentation submitted by the respondent's counsel and had concerns she intended to address. She looked at Sandra directly. "Mrs. Alderson," she said, "I want to be very clear about what I have read in this file. There is documented evidence of financial transfers from joint marital accounts to an entity that appears to have been created for the purpose of receiving those transfers. There is a home equity instrument bearing the respondent's signature that a qualified examiner has determined is not genuine, and there are 3 transfers from your son's account to the same receiving entity." She paused. "Before I determine how to proceed with this matter, I am referring the questioned documents finding to the district attorney's office for review. That referral will happen today. I am also ordering a full forensic audit of all accounts referenced in this file to be completed by a court-appointed examiner before any further proceedings in this divorce action." She looked at Gerald Prout. "Counsel, you will advise your client of the implications of today's referral." He said he understood. She looked at Sandra one more time. "Mrs. Alderson, I have sat on this bench for 14 years. I have heard a great many things. What I read in this file this morning raises questions that go considerably beyond the scope of a divorce proceeding. I would encourage you to think carefully about the decisions in front of you." Then she stood and left. What happened in the weeks after that hearing is not a clean story with a single resolution. Life rarely provides those. What happened was a series of decisions by several people under significant pressure. Sandra's attorney filed for a continuance 3 days after the hearing, and it was granted pending the forensic audit. The district attorney's office opened a preliminary inquiry into the questioned documents finding. Gerald Prout withdrew from representation 6 weeks after the hearing, citing a conflict of interest that he did not specify, which Francis told me was consistent with an attorney who had learned something about his client that he preferred not to be in the room for. Elliot called me 2 weeks after the hearing. I want to tell you about that call honestly because it is the part of this story I have turned over most carefully in the months since. He called from his car, which I know because of the road noise. He said, "Dad, I need to tell you what happened." I said, "I am listening." He told me that Sandra had come to him 26 months earlier with a plan. She had framed it as protecting assets in the event of a divorce that she said she believed was coming, though she had not told me she believed any such thing. She had told Elliot that I had been moving money into accounts she could not access, which was false, and that she needed his help ensuring she had resources to support herself. She had asked him to make 3 transfers into the Meridian structure, as part of what she described as a family protection arrangement. He had believed her. He was my son and he loved his mother, and she had told him a story that made his participation feel like loyalty rather than harm, and he had not known enough about the financial structure to understand what he was actually participating in until Francis's file had laid it out in court. I listened to all of this without interrupting. When he finished, I said, "Elliot, did you know about the forged signature on the HELOC?" "No," he said. "I swear to you, Dad, I did not know about that." I believed him. I believed him because I knew him and because the specific horror in his voice when I said the word forged was not performed. It was the horror of a man learning that something he had been told was a protection arrangement was adjacent to something he would never have agreed to participate in knowingly. He said, "I am going to the district attorney's office. I am going to tell them everything I know." I said, "That is the right decision." He said, "Dad, I am sorry. I believed her version of you. I should have called you and asked." I said, "You should have, but she gave you a version of me that was designed to make calling me feel like a betrayal. That is not an excuse, but it is a context." He was quiet for a moment. Then he said, "Are we going to be okay?" I thought about 31 years of Sunday morning calls, about Little League and college move-in and the first apartment, about a father and a son who had been turned against each other by a story carefully constructed to accomplish exactly that. I said, "We are going to find out." That is an honest answer, and it is the only one I have right now. He said, "Okay." And I heard in that word the same thing I had heard in his testimony in the courtroom, a man doing something that costs him something because it is the right thing. The forensic audit was completed 4 months after the hearing. It confirmed everything in Francis's file, and found 2 additional transfers I had not discovered in my own review. The district attorney's office filed charges on the forged document, which is a felony in North Carolina. Sandra retained new counsel and entered into negotiations that I will not describe in detail because they are ongoing, and because Francis has advised me appropriately on what to say publicly. What I will tell you is that the divorce proceeding has been separated from the criminal matter and is moving through its own process with the forensic audit as the financial framework. Francis tells me I am in the strongest possible position. I accept that without feeling triumph about it, because triumph requires a winner, and I do not feel like a winner. I feel like a man who had to take his marriage apart piece by piece in a courthouse to prove he was not who his wife said he was. That is not a good feeling. I want to be honest about that rather than package it as vindication. Elliot cooperated fully with the district attorney's office. His cooperation changed his legal exposure considerably. Francis told me when I asked that the decisions he made after the hearing were the right decisions and that they mattered. He and I have been having dinner on the first Wednesday of every month since the hearing. Not comfortable dinners, honest ones. The kind where neither of us pretends the last 26 months did not happen and neither of us uses the past to avoid the present. We are finding out, as I told him we would. So far the finding out is producing something I did not know if it would produce. It is producing something worth keeping. Here is what I want to leave you with, because I think it matters and I think some of you watching tonight need to hear it. Document everything. I know that sounds like the advice of an accountant, which I am, but I mean it beyond the professional context. The records I kept, the statements I filed, the returns I organized over 31 years of careful financial management were the architecture of my defense in a room where someone was trying to build a false version of me. People will tell stories about you. Some of those stories will be told in rooms you cannot walk out of and by people whose motivation you did not see coming. The only answer to a false story told with documents is a true story told with better documents. I sat in that courtroom for 4 hours listening to people I loved describe someone I was not. And when the judge read 11 pages of organized, sourced, specific truth, she asked one question that the false story could not answer. One question was enough. Because the truth, properly documented and clearly presented, does not need to perform. It does not need to cry or gesticulate or appeal to anyone's sympathy. It just needs to be in the room. I made sure it was in the room. If this story reached you tonight, hit that like button and subscribe to Dad's True Emotions. Drop a comment below and let me know where you're watching from. I will see you on the next one.